late because I could not get out of my neighborhood. And then we got on and all the lights were off and we got hit last night. But everybody's here, so that's a good thing. Where are we proceeding, Mrs. Ellen?
If we could just start right at the top with Austin Brown.
Austin. That Ms. Donnelly, that's your client?
Yes, Your Honor.
All right. Mr. Brown is in which post?
He's in post 1, visit 3.
All right. All right, so we're on the record in docket 25-01313. That is People of the State of Michigan versus Austin Brown. This is set for probable cause conference. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Austin Brown, who is appearing separately by video from the Lincoln County Jail.
And sir, you are Austin Brown, is that correct?
Sir.
Okay, and you can hear me all right, Mr. Brown?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Mrs. L, how we proceed?
Your Honor, it's my understanding that at this time we'll be leaving the set for a preliminary examination.
All right, and is that a fair statement, Ms. Donnelly?
Yes, it is. There is an offer on that's been extended, and I will be me and Mr. Brown will consider it in the meantime.
All right. So we're leaving on for preliminary examination set for May 23rd at 9 a.m. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in 25-01313, Mrs. L?
Not for the People.
Ms. Donnelly.
No, Your Honor.
All right, Mr. Brown, you're all set. We'll see you next week, May 23rd at 9 o'clock. That'll be next Friday at 9 o'clock.
Thank you.
You're welcome. All right. What's the next case, Mrs. L?
If we could go down the list to Ms. Donnelly's next case, the Aaron Williams case, please.
Aaron Williams. Ms. Donnelly, you were to be here at 2. Mr. Kaplan was covering, I believe, yesterday.
Mr. Lee.
Mr. Lee covered, and I called Mr. Doyle, Mr. Donnelly about 9 times during our prelim. Yeah, and I had to apologize each time. So you were well represented. I just got the name in my head.
Yeah, I understand.
All right. That's Aaron Williams, is that correct?
Correct.
All right, so we're on the record in docket 25-01302. That's People of the State of Michigan versus Aaron Williams. Will the parties please introduce themselves for the record? It is the 6th. Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Aaron Williams, who is appearing separately by video from the Lincoln County Jail.
And sir, you are Aaron Williams, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Williams?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we will be leaving the set for a preliminary examination. No offer has been extended at this time.
And is that a fair statement of Ms. Donnelly?
Yes, Your Honor.
All right. We'll leave on for prelim on May 23rd at 8:30. So next Friday at 8:30. So Mr. Williams, we're leaving on for prelim at 8:30 next Friday at 8:30. Anything else for the record in 25-01302, Ms. Zell?
Not for the People.
Ms. Donnelly.
Not for defense.
All right, Mr. Williams, you're all set. Thank you for your appearance today.
Thank you.
If you want to, that's fine. I've got other things we can do.
You can't be behind me talking and like looking in. You just have to.
Mr. Laredo, you're unmuted, so you should mute if you want to speak.
Sorry about that, Your Honor.
All right. All right, Mrs. Zell, what's next today?
If we go ahead, do you want to do it right now, or do you want to?
I don't go. Yeah, if you want to do them.
All right, if we could jump all the way down to the 9 a.m. docket and do the John White case,
All right.
that's going to be a plea.
All right.
Your Honor, I have the rights if I approach.
You may.
Oh, I'm sorry. I need to approach again. No contest, please.
Oh, okay. All right.
Come on in.
Dante.
Come on here. You need to sit, just sit. Can I have you take your hat off, sir? Thank you.
Well. Thank you.
These are two files on Mr. I don't know. I don't know if I have the right person.
John White.
John White.
John. All right, so we're on the record in docket 25-01165. That's people of the state of Michigan versus John White or John Gilbert Charles White. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Stop.
Assistant Public Defender Sarah Donnelly on behalf of the defendant John Gilbert Charles James White, who is sitting to my right, if Your Honor would allow him, because he uses a wheelchair.
Absolutely. And sir, you are John Gilbert Charles James White? Junior. Thank you. This is time set for a probable cause conference for preliminary examination today. Ms. Ezell, how are we proceeding?
Your Honor, at this time, a plea offer has been extended to the defendant through defense counsel. That offer is to plead to an added count 2 of assault and battery upon successful, or I'm sorry, the PAC code for that being 750-81, which is a 93-day misdemeanor and or $500 fine. Upon successful plea and sentence, we would be dropping count 1, the felonious assault, and the habitual offender notice.
And is that a fair statement of the plea offer, Ms. Donnelly?
It is, Your Honor. At this time, my client would like to accept it, but plead no contest if the court would allow due to civil liability.
For the potential for civil liability?
Yes.
And if there's no objection to the no contest plea, Ms. Ezell?
No objection, Your Honor.
All right, you've indicated an advice of rights, sir, and you've signed the bottom of this advice of rights. There are 12 rights, and you've signed the bottom of that. Is that correct, sir?
Sure.
All right, thank you. So I'll go over the main ones with you. You have 3 main rights in this matter. You have the right to be tried by a jury. You have the right to have counsel. You are represented by attorney Sarah Donnelly. She would be present to cross-examine any witnesses or contest any charges. And you have the right to choose to testify or remain silent at your own trial. Do you understand those rights, sir?
Sure.
All right. If the no contest plea is accepted, you'll give up the claim the plea was the claim that the no contest plea was a result of any promises other than what we placed on the record or threats that it was not your choice to plead no contest. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading no contest to the misdemeanor assault and battery. Is it your still wish today to plead no contest to this charge? All right. I'm in possession of a LPD report or Lansing Police Department report of 255-190-3419. Ms. Donnelly, this is what I'm going to use for the factual basis. Is that correct?
Yes, Your Honor.
And is that a fair statement, Mrs. L?
It is, Your Honor.
All right. So there's an indication that on the Lansing Police Department for the reason we're using the no contest plea is the potential for civil liability, that this all occurred on August 18th, 2025 at 505 Townsend Street in the city of Lansing.
Let me come down to you looking for this. Probably something would. Talk to anybody.
So, defendant John Gilbert Charles James, looks like you had an argument with Raymond Baumgartner. And at that time, he was approximately 2 feet away, and it would say pulled a black handled knife with a black or gray blade and held it to him. Raymond Baumgartner said John told him that he would stab him. That would make the factual basis for the assault, felonious assault. We can take it as a misdemeanor. That's also an offensive touching, and there's nothing nothing to indicate that it was done in self-defense. There were no injuries to speak of. Is that a fair statement? Anything towards a factual basis, Mrs. L?
No, Your Honor.
Miss Donnelly?
No, Your Honor.
I'm gonna find that the no contest plea, the factual basis is confirmed. We're gonna refer to probation. So, Mr. White, you should go to the 5th floor all the way to the right, and that's the probation department. They'll either see you now or have or set up a meeting for you. And then they'll see, we'll see what options are available to us at sentencing. Okay, sir? All right.
What's the
So sentencing date of?
July 17th at 8:30.
July 17th at 8:30. All right. So Mr. White, we'll see you back here on July 17th at 8:30. Anything else for the record in 25-01165, Mrs. L?
Just briefly, Your Honor, it's been brought to my attention from the victim in this case that Mr. White has been back at the apartment building where the victim resides. At this time, we do not seek any violations in bond, but we would ask that bond conditions be reminded on the record.
All right. Miss Donnelly, that's news to you. Is that correct?
It is this morning, yes.
All right. So there's still a no contact order. There's still no contact order. So the same pretrial conditions apply regardless. Only doing that because that's in protection of yourself. All right. If the allegation's made that you violated the no contact order, then you're the one who's going to suffer for it, and it's going to affect your probation. All right, sir. All right. All right. With that warning, the no contact order and all the pretrial conditions still stay in place, but especially the no contact order in regards to Raymond Baumgartner. And then we will readdress these issues, see what options are available to us at sentencing on July 17th at 8:30. I'll return the police report to Ms. Donnelly for the no contest plea, and we should be all set. Thank you for your appearance today, sir. Mr. Silver. Darian Jackson. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
And Mr. Sarts, you're from the public defender, and we're placing the substitution on the record. Is that correct?
Yes, please, Your Honor. That will help expedite the process.
All right.
If Your Honor would just sign a substitution order, that would be greatly appreciated that way. And Mr. Jackson and Ms.
All right.
Patrick can get her discovery quicker.
All right. I don't know if I have an order yet, a substitution of counsel.
You don't have anything.
You don't have one,
All
Your
right.
Honor. We're hoping we can just handle this portion of the record and we can get the order to you.
All right. All right. So this is substitution of counsel and this is set for
Probable cause conference.
PCC. Ma'am, your appearance for the record.
Good morning, Your Honor. I'm Melissa Patrick.
All right. So I'm awaiting the request for substitution of counsel that we placed on the record. Mr. Sarts was the initial attorney, and now Ms. Patrick has stepped in, and I'm awaiting the order to sign for discovery purposes, because of course, Ms. Patrick doesn't get discovery until she files an appearance, and that's what we're looking to expedite in this matter.
Your Honor, just
Yes,
for clarification, I filed an appearance on Tuesday and I have received discovery already.
you have.
I have.
The
All right.
prosecutor's office received her appearance on it. It looks like the 13th.
All right. We don't have anything. So,
We emailed it to the court.
okay. So it hasn't made its way to the computer.
Yeah. I'll file one on the way out.
All right. So how are we proceeding today? We have a substitution of counsel. We do have some discovery that has made its way to to Ms. Patrick. Did you want to leave this on? How did you want to proceed?
I believe leaving it set for the preliminary exam would be fine, but I'll defer to Ms. Patrick.
Ms. Patrick.
That is correct, Your Honor. No offer has been made and I expected that to be the case today. Mr. Jackson wants me to address an issue with the court. Mr. Jackson and the alleged victim in this case share a child. And when he was arraigned, he tried to address the exchanges for his parenting time with that at that arraignment, and he was referred to Your Honor in order to accommodate that.
Right. So there's a no contact order with the victim in this matter, I would assume,
Yes, Your
which
Honor.
is what places him in violation of the family court order.
Correct, Your Honor.
That is with. So until I hear from Ms. Brody, we'll act on the order. The pretrial services order for no contact and for GPS on. It looks like Maria Vanilla Brody it has a different goal than the domestic case, as you know. So let's wait to address this at prelim. Okay, we'll wait to address it prelim. I'm assuming that because I'd like to hear from Ms. Brody what the no contact order is, and if she says it's all right, she can put it on the record. We can modify the order.
So just for clarification, there's no orders in the circuit court at all?
I don't know.
At all?
I have no idea about.
Yeah, that's what I
family
was letting the court know. There's
Yeah.
nothing.
So the only order now is a no contact order that's a part of the pretrial
Correct.
bond condition.
Yeah.
As far as I know. So is Mrs. L, is that a fair statement?
It is, Your Honor.
I only know of the no contact order concerning the arraignment here.
So my client just wanted to let you know that there is a third party that is available if necessary to exchange the child.
All
That
right,
will
and that will become an issue, I think, next week
Understood.
when we address it with the victim and see if modification of bond for the third party contact is in order. Without having the victim here, I'm just reluctant to do anything.
Understood.
All right.
Thank you.
All right, so we'll leave on for preliminary examination on May 23rd at 9 o'clock. Anything else for the record in 25-01347, Mrs. L?
Yes, Your Honor, I would just like to I misspoke when I spoke to Ms. Patrick earlier. There is an offer in this case. The current offer would be to plead to count 3. Upon successful plea and sentencing, the remainder of the counts would be dropped. And I do apologize for misspeaking earlier.
All right, so the count 3 is the offer, and I'll leave counsel to negotiate or to talk more about the count three, but it's a plea to count three. Counts 1 and 2 are dismissed, and the record would indicate that offer's been made.
Thank you.
Anything else for the record in 25-01347, Ms. Patrick?
No, Your Honor, thank you so
Mr.
much.
Sartz, anything else for the record?
Just to clarify, Your Honor wants a substitution order, correct?
Yes.
Okay.
Yeah,
thank you.
at least if it's once already filed, I want it in the computer because the computer doesn't have it, or you can file a new one. It doesn't matter to me.
Understood, Your Honor. Thank you.
Thanks.
Thank you, Your Honor.
Something quick, need permission.
Can you approach real quick? I'm sorry.
Sure, Mr. Milks. I'm assuming that's on Lewis.
Yes.
Fire my lawyer. Okay.
Mr. Arnold, can you hear me?
Yes, sir.
What post are you in?
In post 2, cell 6.
Sir, what's your name? In visit 7? All right, you're gonna have to stand by and we're in the middle of a hearing right now. So just, you'll have to stand by but not say anything.
I just had to move because I got blood clots in my body.
All right,
And they're
all right,
tingling.
sir, you gotta stop talking, all right? You're in the middle of a hearing. So the other thing we can do is put you on mute and you'll be muted, but I don't want to do that.
Phones are now unmuted.
Hello?
You here now?
So you're trying to approach the car, you approach the driver's side,
Correct.
and you approach from a vantage point as to where you could see all occupants you thought were in the car,
I approach at the best angle to have a tactical advantage, yes.
which included being able to observe the passenger.
Correct.
Did you see the passenger make any gestures in that car on your approach?
I said no.
No further question.
All right, redirect, Ms. Izell.
No, Your Honor.
All right, may this witness be excused from the people?
You may.
Mr. Kaplan.
Yes,
Mr. Johnson, may this witness be excused?
yes, Your Honor.
All right, thank you for your appearance today. You're all set.
Thanks, sir.
And Mrs. L, are the people ready to call their next witness?
We are, Your Honor. At this time, the people call Sergeant Scott Williams to the stand.
Right, Sergeant Williams, have you come forward? And have you please state and spell your first name and last name for the record?
Sergeant Scott Williams, Scott Williams.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Right, go and have a seat. The microphone goes to the court recorder's ears, as you know, so please project as best you can. Mrs. L, when you're ready.
Thank you, Your Honor. Thank you for being here today, Sergeant. If you could just start by telling me where you're currently employed
Currently employed with the Michigan State Police.
and what's your current role there?
I'm current sergeant under the Secure Cities Partnership here in the city of Lansing.
And how long have you been in that role?
I've been in this role just approximately 2 years,
And how long have you been an officer with MSP?
over 9 years.
And were you working on April 8th, 2025?
Yes, sir.
And do you recall being part of a traffic stop that day? And do you recall what the reason for that traffic stop was?
I believe it's for speed.
And were you part of the, I'm sorry, were you the trooper who made that stop?
No, it's true.
Thank you. And when did you arrive at that stop?
I was riding passenger, so I was with her during the entirety of the stop.
Thank you. And when you arrived and the, let me back up a little bit. When the car pulled into the parking lot and stopped, how did you approach the vehicle?
Trooper Morgan made a driver's side approach and spoke with the driver, and I made a passenger side approach as there was a front passenger and a passenger.
And who did you make contact with?
The passenger side, both of them, kind of watching, looking inside the vehicle, make contact with them, making sure safety.
And did you observe anything at that time?
I observed an alcoholic container.
Can you tell me what that alcoholic container
I
was?
don't remember the exact brand. It was a beer bottle. It was in the back seat, back up and forward.
Do you recall if it was open, closed, full, empty?
It was open. I don't remember checking to see if it was full or halfway full or what. It was,
And at any point, did you check to see if there was any alcohol in it at the time?
I did not, due to the totality of the circumstances, what occurred later on. But I don't know if someone else did search the car because I didn't search.
And so based on that alcoholic container in the car, how did you proceed?
I notified Trooper Morgan. I was like, why don't you go ahead and get him out of the car and we'll investigate that further.
At that point, were all occupants asked to exit the vehicle?
The driver was asked to exit. And then prior to the next name is when Trooper Morgan said he observed the fire.
And when you heard that there was a firearm, how did you respond?
I told him to stay there. I came around the front of the drive to the driver's side of the vehicle. And then once I was over there, that's where Trooper Morgan took possession of the driver's arms, had him step out, place him in custody, and then I removed the firearm from the vehicle.
And so when you observed the firearm, where was it located?
Just underneath, basically between the pedals, driver pedals, and under the seat, it was kind of like sticking out to the front of the seat area.
What portion was sticking out?
Pretty much the butt of it, but definitely probably half of the firearm.
And you could see that clearly?
I could see it with the door open, yes, but Trooper Morgan observed that prior. He's the one that notified me.
And so you took possession of that firearm? What did you do with that firearm?
I cleared it, took it back to my patrol car, and made it safe before we started cleaning up the subjects.
And when you say you cleared it, what do you mean by that?
By clearing it, you take the magazine out, make sure the chamber's safe. There was one round in the chamber, and then make sure that it's safe. That it does not go off or immediate possession of someone else.
And then how did you proceed after that?
At that point, I believe Trooper Harshman, Trooper Jones arrived. They made contact with passengers. And at that point, I basically was just helping Trooper Morgan with lien checks, file checks, and everything on our computers.
And to your knowledge, was anything else found on the scene?
Yeah, cocaine.
And did you have any interaction with that cocaine?
I did not know.
You didn't?
Not at the scene.
Not at the scene? Okay. So after, did you at any point conduct tests on that suspected cocaine? And what were those tests?
I did a TrueNarc scan back at the Lansing Post, and it came back positive for cocaine.
And was the suspected cocaine weighed at all?
I imagine it is. Anytime any property is added into our reports, it's weighed and tested.
And do you recall what the weight of it was?
Not off the top of my head.
No further questions at this time.
Cross-examination, Mr. Kaplan.
Thank you, Your Honor. Good morning, Trooper. Or Sergeant, right?
Yes.
Sergeant, okay. You said you found or you saw an open container of alcohol.
Correct.
Where?
It was on, I believe, on the black back like floorboard behind the front passenger seat.
On the front passenger.
I believe so.
All right. Well, I want you to know, not.
I can't tell you. That's what I recall off of it. I didn't put it in the report, so
Okay.
I just remember observing it.
Was this a can or a bottle?
I can't tell you off the top of my head. I don't recall.
So you don't know what kind of top it would have had on it?
No, I remember telling Trooper Morgan he can open the container of alcohol. That's all I recall.
I guess I'm asking how you knew it was open. If you don't recall what kind of container it was.
I can't tell you from what I remember now.
Okay.
I believe what I meant at the time.
You said you didn't find the cocaine.
Correct.
Okay. So there was also a passenger in the backseat, correct? Was that on the driver's side or the passenger side?
I believe it was on the passenger side.
Okay, you're not sure?
I can't recall, to be honest.
So you don't recall then if the can was, you saw it between somebody's legs or, on the floor between their feet or not? That
I don't recall the exact location.
Okay.
I just remember notifying Trooper Morgan that there was no container.
Okay, thank you. I think that's all I have. Thanks.
Cross-examination, Mr. Johnson.
Sir, as you were exiting the vehicle, you were making observations of the occupants of the vehicle, correct?
Yeah, normally I'll make sure, to watch people's hands, see what they're doing, moving around the vehicle, things of that nature.
This is for your safety and the safety of people you're working with, correct?
Correct. Yes, sir.
Did you observe the passenger of the vehicle of Ms. Hauser make any gestures whatsoever?
I didn't notice anything, no.
No further questions, John.
Any redirect of this witness, Mrs. L?
Just briefly, Your Honor. I know you mentioned there was one round in the chamber of the gun. Was there any other ammunition found?
In the magazine itself.
And how much ammunition?
It would be in the report. I don't know the exact round count.
Okay, thank you. No further questions.
Mrs. L, may this witness be excused.
Yes, Your Honor.
Mr. Kaplan, may this witness be excused?
Me, Your Honor.
Mr. Johnson, may this witness be excused?
Yes, Your Honor.
Right, you're all set, sir. Thank you for your appearance today. Further proofs, Ms. Zell.
Yes, Your Honor. The people would like to call Trooper Stephen Jones to the stand.
Right, Trooper Jones, I'm gonna have you state and spell your first name, your last name for the record.
Stevin, Stevin, last name Jones, J-O-N-S.
Okay, please raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, have a seat. The microphone is for recording purposes, so please project to the best, to the back of the room as best you can, as you know, and Mrs. L, when you're ready.
Thank you, Your Honor. Thank you for being here today, Trooper. At this, just to start off, could you just tell me where you're currently employed?
The Michigan State Police Lansing Post.
And how long have you been employed there?
I've been at the Lansing Post for about 3 months.
Where were you before that?
I was at Flint,
So how long have you been an officer?
4.5 years.
And what's your current position with MSP?
I work with the Secured Cities Partnership.
And do you recall working on April 8th of 2025?
Just me.
And do you recall being involved in a traffic stop that day? And were you the initial troopers that conducted the stop? When did you arrive at the stop?
When they requested assistance.
Do you recall when that was?
Not the exact time.
When you arrived, what did you observe?
I observed them speaking with the driver. And then they then proceeded to get the driver out of the vehicle.
And what were you doing in that time?
Just there for assistance.
Right, so once they got the driver out of the vehicle, what information was relayed to you?
Like there was a firearm.
And based on that, how did you proceed?
I was then moving to the passenger side of the vehicle.
And did you make contact with anyone in the vehicle?
Yes, ma'am.
Who did you contact?
Autumn House.
And how did you identify her?
That I cannot recall.
Would you recognize Miss Hauser if you saw her again?
Yes, sir. Yes, ma'am.
Is she present in the courtroom today?
Yes, ma'am.
And could you please describe her by something she's wearing?
Blue, ma'am.
Thank you. At this time, Your Honor, the people ask that the identification of Miss Hauser be entered into evidence.
Any objection to Ms. Hauser being identified by the witness for purposes of prelim, Mr. Johnson?
No, Your Honor.
With that understanding, the witness has identified the defendant, Autumn Hauser, and you may proceed.
Thank you, Your Honor. Once you contacted Miss Hauser, did you have her step out of the vehicle?
Yes.
And did she do that?
Yes, she complied.
And when she stepped out of the vehicle, did you observe anything?
Yes, I observed a clear plastic bag with a white powder substance
And where was that?
on the passenger seat.
And that wasn't visible before Miss Hauser stood up?
Correct.
Once you saw that, how did you proceed?
I placed her in handcuffs.
And did you then confiscate the drugs at that time?
No, I did
Who confiscated the drugs?
not. It was Trooper Harshman and Officer Booth.
Once Miss Hauser was taken, placed in the handcuffs, how'd you proceed there?
I secured her now patrol.
When she was secured in the patrol vehicle, were her Miranda rights given to her?
By Trooper Morgan, yes.
Thank you. No further questions at this time.
Mr. Johnson, cross-examination.
Sir, you arrived on scene and you were notified that there was a weapon in the vehicle.
Sir.
So that heightened the level of this traffic stop. Correct?
No.
A weapon being in the vehicle didn't elevate this from a normal speeding ticket traffic stop to a felony stop?
More dangerous, but I was now more elevated.
Okay, so it went from a more dangerous traffic.
Correct,
stop.
yes.
Okay, so now you are definitely paying attention to all occupants of the vehicle, correct?
Correct,
There could be more weapons in the vehicle.
correct.
Did you make any observations, Ms. Hauser, making any gestures?
Not that I could see, sir, no.
No further questions.
Mr. Kaplan, do you have any questions of the trooper?
We do not, Your Honor. Thank you.
Any redirect, Mrs. L?
Just briefly, Your Honor, Trooper Jones, do you happen to know how much cocaine was found?
Not per se.
Okay, thank you. No further questions, Your Honor.
All right. May this witness be excused from the people?
You may, Your Honor.
Mr. Kaplan, may this witness be excused?
You may, Your Honor.
Mr. Johnson, may this witness be excused?
Yes, Your Honor.
All right. Thank you for your appearance. You're all set.
Thank you, sir.
Mrs. L, you may call any further proofs.
Potentially, Your Honor, may I have just a couple of minutes? Thank you.
On the Motorola Moto G, you'll have to unmute. Can you please identify yourself for the record? You're all, I see you, Mr. Silverthorne, you're all right. On the Motorola Moto G cell phone, you'll have to unmute and identify yourself. What's your name, sir?
Antoine Mitchell. Hey, make it sound like he gonna get me drunk. What?
What case are you here on, Mr. Mitchell?
I think a gun case. I supposed to talk to my lawyer.
I don't have you on the docket, Mr. Mitchell. So what's the number of your case?
It said on the 16th I had court, Zoom court.
Okay, I don't think you're in the right courtroom. What's your full name, sir?
Antoine Dwayne Mitchell.
All right, let me look you up and I'll let you know where you're supposed to be.
Okay.
Sir, you're supposed to be in front of Judge Ward. That's a different judge.
Oh, I got court on the 23rd, so it said the 16th at 9:30.
I'm only telling you that your case, you should probably go to Judge Ward's because there'll be a bench warrant issued if you don't appear. You're in front of Judge Ward.
So I gotta go in. They just said it was just a Zoom.
They gave you that.
You can go by Zoom. You just have to be in front of Judge Ward, not Judge Flores.
So how do I do that?
You should contact the civil department, get Judge Ward's identification number to get on the Zoom call.
Okay.
All right, thank you.
What's your name?
My name is Judge Flores. You're in the wrong courtroom.
Okay, thank you. And then you're gonna call the courthouse.
Okay, thank you.
All right, thank you. We're gonna put you on mute now, sir.
All right.
Sign comes around, my mom shut those. I should have done this too. You're not on court thing, right?
Ma'am.
You are?
Mm. I'm just being, it's a long story. I've taken long notes of the screw up. I just hate wasting time. So I'm working on other cases. Only this is some, in fact, double billing.
From my house.
But okay, I'm just moving around things. What is it?
Essie, Eric, Ray, Sean, Brandon, Steve, and I don't know who else. Maybe some of her from golfing tomorrow at Timber Trees. I don't know if you wanna go. I told her he'll probably say no, but I'll ask.
Yeah, I'd like to go. What?
And
Things gotta get done around here. I gotta put those flowers
Me and you
in.
could make the fine, but it's just, we got too much to do. I'm gonna go out and clean the car out right now and hopefully get the cutting along.
If you get to, if I hook the hose up, if you think about it, could you just get what the rain didn't get off my car? Take you a second.
If I get to it.
If you get to it,
Yeah.
that's all I said. If you get to it,
I'm not gonna get,
if it's not important,
the car wash,
I'll do it.
then tell Ray, I'm not.
He was offended that I would, he was offended that I was offended.
So I think we're gonna pick up Sean and.
I don't know what it is.
Over here in Grove. Six one eight four four seven.
Hello? I'm what?
All right, this was set for sentencing today, so we're on the record in docket 25-00520 FY. That's people of the state of Michigan versus Damian Brown. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Brown.
And sir, you are Damian Terrell Brown, is that correct?
Yes, sir.
Thank you. All right, this is the time set for sentencing in the matter. Ms. Robinson, have you had the opportunity to go through the pre-sentence report with your client?
I have, Your Honor.
Any additions, deletions, or corrections?
I don't.
Is there any restitution on this case of Mrs. Zell?
Do not believe there is, Your Honor.
All right. Allocution, Ms. Robinson.
Yes, Your Honor. We'd ask the court to follow the recommendation put forward in the PSI, sentence Mr. Brown to a term of 8 months of probation. Currently, Mr. Brown is working. He works at Amazon doing deliveries, is doing well there. As stated in the PSI, he doesn't qualify for any sort of substance abuse disorder. So I really think this is sort of like a one-off incident with Mr. Brown in this case. He is willing to complete the requirements of probation, abide by the law, and do what's required of him to show the court that he's changed.
Thank you. Is there anything you'd like to say, Mr. Brown, to the court before the court passes sentence?
I can do probation.
Okay. All right. So this is for the guilty plea. The defendant was found guilty in a guilty plea on March 15, 2025 under the for the use of a controlled substance. It is the order of the court that the defendant is to spend 0 days in jail. Credits given for 2 days previously served. So 2 days in jail, credits given for 2 days previously served. I'll suspend a remaining 45 days upon successful completion of probation, so there'll be no upfront jail, all right? And then probation, so the count one fines and costs will have $200 fines, $200 costs. Crime victims' rights fee of $75, state minimum court cost fee of $50, and then probation is $30 a month at 8 months via Zoom. I'll give you a total of that, 400 plus 125 plus 240 equals 765. You're on probation for 8 months via Zoom. Abide by terms of probation, $30 per month. I'm also ordering no assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. This is the kicker, because this is what most people fail on. Okay, so just so you know up front, you're going to be submit to random PBTs, and your analysis is directed and pay fees. Once you submit, and if they're going to treat a non-drop as a dirty drop, all right? And so just be aware of that, all right? That's what I'd say 70% of my cases are people for dropping dirty or failing to drop, right? No bars or nightclubs, probably a good idea. Complete following rehabilitative services will be substance abuse education at the direction of your probation agent. Outpatient held in abeyance pending positive tests. So they're going to hold there's no reason to think that you have a destructive relationship with narcotics, okay? But if you test positive, we have to reassess, all right? And that's what the district court services are for, all right, sir? Obtain and maintain employment, you've already done that. Not purchase or possess firearms, ammunitions, or weapons of any kind. And this will be abstractable to the Secretary of State as a use of control abstraction. Anything else for the record in 25-00520, Mrs. L?
Not for the people.
Ms. Robinson.
No, Your Honor, thank you.
All right, Mr. Brown, I'm going to sign. Do you have any questions to me concerning the judgment of sentence?
I don't know what that last part about this Secretary of State is.
Yeah, the Secretary of State will be this is an abstractable offense. They can be reported to the Secretary of State. I don't know if they'll do anything concerning your license, but that administrative agency, the Secretary of State, will be notified of this. All right. All right. I will sign the judgment of sentence accordingly. Who is your probation officer, sir?
I'll have.
It's usually the person who wrote the report. Mr. Neves, is it?
Yes.
Yeah. All right, so Mr. Nev's a pretty fair guy, all right? So he'll work with you in this case, all right? All right, make sure you're on board with how you're supposed to report and everything else in this matter. You should be all set, Mr. Brown. Thank you.
You're all set.
All right. And then did you want to call Maury Curtis? That's
We are
next on the
ready.
list.
You got- she was not. Is Carter?
If people have been here since 8:30.
Oh, yeah, we've got a packed, hot, humid room with lots of trees and everything falling apart. So, all right, so we're on the record at 25-0. I didn't lose power last night, though. That's good. But a lot of people did. A lot of people lost power. So we're on the record in 25-0-1305. That is people of the state of Michigan versus Maury Curtis. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Ms. Curtis.
And ma'am, you are Maury Ann Curtis, is that correct? Yes. All right, thank you. This is the time set for a probable cause conference. Mrs. L, how we proceed?
Your Honor, at this time, an offer has been extended to defense counsel for this case. The offer would be to plead to an added count 3 of OWI and to count 2 the assault and battery. Successful plea and sentencing, we would drop the count 1. At this time, Your Honor, we do not have the blood results to support the factual basis for the OWI charge. We would ask for an adjournment of this PCC to get those blood results.
All right, and is that a fair statement, Ms. Robinson?
It is.
In order to, it's going to take a while to get the blood results. Is your client willing to waive for, we're having a prelim within 21 days so we can wait for the blood results?
She is.
To come back. All right. May I inquire of Ms. Curtis of a waiver of the 21-day rule?
Yes.
All right. All right, Ms. Curtis, you understand you have a right to a preliminary examination within 21 days of your date of arraignment.
Yes.
A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Aaron Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a preliminary examination within the 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period. So we can wait for any more discovery. We're waiting for blood results. Okay. And that usually takes 30 to 40 days, okay? Is it your wish today to waive your right to a preliminary examination within the 21-day period? You'd have your prelim outside of that date.
Yes.
And Mrs. L, do the people also waive their right to a prelim within 21 days?
We do, Your Honor.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And so we're awaiting discovery, essentially. And we're going to reset this for preliminary examination. And we'll reset it after 30 days because I know it takes some time. Do you want an additional PCC or prelim?
I would defer to Ms. Robinson on that.
Whatever the court prefers.
All right, whichever we.
Let's have her another.
Okay. All right.
June 13th at 8:30.
We'll set it for June 13th at 8:30 for PCC, which means that Ms. Curtis, you could come via Zoom if you choose to. All right, at the probable cause conference. All right, that option is available to you. We'll set for PCC, and then we'll go from there. I don't think witnesses would be required for PCC. Is that correct?
Correct.
All right. All right, that's all for the record in 25-0-1-3-3-0-5. We've set it for PCC on June 13th at 8:30. Anything else for the record on that file, Mrs. L?
No, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Ms. Curtis, we'll see you on that date. Thank you for your appearance. Who's Mr. Feigelson today?
I am.
Okay. Did you want to go on? I'm just going in order, so.
Yes, we could go on, Mr. Frazier, that would be wonderful.
All right.
Thank you.
All right, so we're on the record in docket 24-02956. That is people of the state of Michigan versus Devin J. Frazier. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder, on behalf of Mr. Frazier, filling in today for assigned counsel Steve Feigelson. Mr. Frazier joins us from the Ingham County Jail.
All right, thank you, Ms. Schroeder. And sir, you are Devin Frazier, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Frazier?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Azell, how are we proceeding?
Your Honor, I'd like to defer to I'm sorry.
Okay.
Ms. Schroeder?
Thank you, Ms. Schroeder.
Not the first time, it won't be the last, and worst people to be confused with. At this time, Your Honor, the defense would be asking this matter be left set for preliminary exam. My understanding from Mr. Feigelson is that there are some ongoing discussions regarding potential resolutions, but we would ask that they be left on. Thank you.
All right, so we'll leave on for preliminary examination, which is set for May 23rd at 8:30. So Mr. Frazier, Mr. Feigelson will be out to see you. We've set it for May 23rd at 8:30, and negotiations are ongoing with the people of the state of Michigan. Anything else for the record in docket 24-02956, Mrs. L?
Not for the people.
Ms. Schroeder?
Not for the defense. Thank you.
All right, you should be all set, Mr. Frazier. Mr. Feigelson will be out to see you, and you're set for next week. Thank you.
I believe next on the list would be an AG case. The AG is appearing via Zoom. I believe they are ready for that case if you are.
Captain. And Mr. Laredo. Ms. Robinson, you're here on that case?
I am.
All right. All right, so we're on the record in docket 25-01285. That is people of the state of Michigan versus Alexander Laredo. Will the parties please introduce themselves to the record? Mr. Papin.
Good morning, Your Honor. Craig Papin appearing on behalf of the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Laredo.
All right, and is Mr. Laredo present today?
I am present, Your Honor. Would it be possible for me to speak to Miss Aaron in a breakout room?
Yeah, before or after, it's up to you.
We can do that after.
Okay. Well, Mr. Laredo, I'll await Miss Robinson's appearance, and then we'll put you in a breakout room with her, and then we'll put it on the record. All right, sir?
Thank you, sir.
All right, so Mr. Papin, I'll recall the case in just a minute.
Thank you, Your Honor.
Dwayne Williams.
We can do that right now, Your Honor.
Are you here for Mr. Goodrich?
I'm covered, yes.
All right. All right, so Ms. Robinson, I'm going to put you in room 1 with your client. Or room 2. I'll put you in room 2. And then Mr. Laredo. Oh, you put him in room 3 already, didn't you?
That was from earlier. They had spoken earlier.
All right. I'm going to put him in room 2. So Mr. Laredo, you'll get a prompt to go to room 2. All right. All right, so we're on the record in 25-00664. That is people of the state of Michigan versus Dwayne Williams. Will the parties please introduce themselves for the record? Mrs. Ellis.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Net.
Thank you, Your Honor. George, and on behalf of the Public Defender's Office representing Mr. Dwayne Demetrius Williams for purposes of sentencing today, Your Honor.
All right.
Covering for Attorney Lou Goodrich.
All right. And sir, you are Dwayne Williams, is that correct?
That's correct.
All right, thank you. All right, this is the time set for sentencing in the matter. Mrs. Zeller, do you know of any restitution in this matter?
Do not believe there's any restitution.
Mr. Ned, have you had the opportunity to go through the pre-sentence report with Mr. Williams?
Yes, sir. I may have your my client.
You may.
Mr. Williams, do you understand that we discussed this PSI and went over it this morning?
Yes, sir.
Do you know that I'm not the attorney on record or the attorney to help you with this case?
Yes, sir.
And knowing all the information and going through what we talked about, you're okay with me representing you today?
Yes, sir.
All right. Your Honor, may I? I'm all set.
Okay, thank you. So you did have the opportunity to go through the pre-sentence report with your client. Any additions, deletions, or corrections?
No, Your Honor.
Okay. Allocution on behalf of Mr. Williams, Mr. Ned.
Thank you, Your Honor. First, thank Mr. Williams appeared this morning at 8 o'clock, has been patiently waiting. This is the second time I met him. I think I met him on the civil infraction case earlier this week that stemmed from this incident. He's been calm, cool, and courteous this entire time, very respectful. We did talk about this a little bit. We're asking for the 6 days jail credit, Your Honor. We ask that you follow the recommendations, given the circumstances involved in this case. And if you're open to a fines and cost sentence, Your Honor, we'd also look into that if that's possible, just because he's already being supervised by parole in an unrelated matter. He started a job 2 months ago, being a high-low driver, making about $18.50 per hour. He is currently in a home trying to figure out new housing situations. Alcohol and drugs, I don't believe is an issue in this matter. So we would also like to address the testing too, if that was ordered. Other than that, Your Honor, people ask that we follow the recommendations, but if are open to fine and cost sentence, because to some circumstances, he is currently being supervised and this face repercussions with parole regarding this incident, Your Honor.
Right, thank you. Mr. Zell, is there anything you'd like to say to the court before the court passes sentence?
Yes, Your Honor. We would disagree with the ask for fines and costs on this case. We would ask that the recommendation of probation of the Zoom recording for, I believe, a 6-month term would be proper in this case. I understand that the defendant is currently already on parole with another agency, so we wouldn't mind if that probation just went to non-reporting, so we didn't have the double testing and no additional costs for the defendant for that. But we would like him to be on probation with this court. Thank you.
Thank you. And that the probation agent is Mr. Hanna, is that correct? Brendan Hanna did the report?
Yes, sir.
All right. All right, so this is for a guilty plea to attempt to R&O. It was a motor vehicle, it stemmed from a motor vehicle stop or case, I don't know, but that's what it stemmed from. So I will follow the recommendation of the attempt R&O from the March 20th, 2025 date. I will order that the defendant spend 6 days in jail, credits given for 6 days previously served. I will suspend the remaining 45 days upon successful completion of probation. We'll set fines and costs at $200 fine, $200 costs, crime victims' right fee of $75, state minimum court cost fee of $50, and probation for $180. And I'll give you a grand total of that. 75 plus 50 plus 180 equals 705. You're placed on probation for 6 months via Zoom pursuant to Mr. Hanna. He may want you to contact him in a different manner, and that some of that understanding you're also being supervised by the parole agent. So let Mr. Hanna figure that out, how he wants that supervision to take place. This is an attempt to R&O from a car case, and so we have to take this has to be taken somewhat seriously, okay? Based on the R&O, mostly from it stems from a stop that occurred. I would say a traffic stop on Edgewood Boulevard. So probation is for 6 months via Zoom, pay fees and pay $30 per month. That's indicated. No assaultive or threatening behavior, no use of possession, alcohol, marijuana, or controlled substance without a prescription. You are to submit to random PVTs and urinalysis as directed by Mr. Hannah. That may be done in conjunction with your parole, okay? I'll leave that up to Mr. Hannah. He's a pretty flexible guy, all right? Mr. Hannah is a pretty flexible guy. And so keep in contact with him, all right? That, because this should be somewhat a learning experience, but you're also under different supervision, so that they'll be in contact. No bars or nightclubs, probably a good idea. Follow any of the parole, any other supervisory orders that come out of MDOC. Obtain, maintain employment, not purchase or possess firearms or weapons of any kind. Anything else for the record in docket 25-00664, Mrs. L?
Not for the people.
Mr. Aned.
Two things, Your Honor. Are you able to move the payment plan a few months out? Is that something we can do here?
It will be, we can, what usually happens is the payment plan will go for 6 months. You can pay that over the course of probation. If that becomes a problem, then it'll be referred to collections. All right, so they'll be referred to collections, and you can set up your own payment plan. That's generally how this works. Okay, and that's generally Mr. Hannah's pass, or that's his path. Any other questions, Mr. Annette?
Is this case eligible for early discharge, Your Honor?
I think this case may be eligible for early discharge. And Mr. Hannah, you can bring that to his attention. That would be in 3 months, but everything else has to be taken care of. All right. So I'll wait to hear from Mr. Hannah, the probation agent, if this case is a case that can be indicated. He may say it's not for his various reasons, but I'll wait to hear from him. All right. All right. Anything else?
No, Your Honor.
All right.
You.
So, Mr. Williams, I think Mr. Hannah is going to be your probation agent since he wrote the report. So he's the person you want to stay in contact with. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 25-00664, Mrs. L?
No, Your Honor.
Mr. Ned?
No, Your Honor.
Good luck to you, sir.
Thank you, sir.
Yeah, we're still collecting on the next hearing because we're trying to find Mr. Johnson's here on Mr. Pappin's back. All right. Ms. Robinson's back. Okay. All right, so we're back on the record in docket 25-01285, and Ms. Robinson, you'd had the opportunity to speak with Mr. Laredo in
Yes,
a breakout
for a
room.
second time I did.
All right, thank you. So how are we proceeding today, Mr. Pappin?
Your Honor, we have an offer that is contingent on waiving the probable cause exam. The offer essentially starts that Mr. Laredo owes a child support arrearage of $19,504.35 with a continuing monthly obligation of $516. The offer is that if Mr. Laredo reduces his arrearage to $14,600 or below by the time of plea, he may plea as charged with a recommendation of an 11-month delay of sentence. During the delay, he's to pay his child support as ordered. If, however, he's able to reduce the arrearage to $9,700 or below, we would amend the information to a single count of attempt failure to pay. Further, if he's able to pay his arrearage in full, we would amend the information to a single count of disorderly person.
Right. And Ms. Robinson, is that your understanding of the plea offer that's been placed on the record?
It is.
So how are we going forward, Ms. Robinson?
Yes, Your Honor. Mr. Laredo will be waiving his preliminary exam.
All right. So the offer's been placed on the record, Mr. Laredo, and you'll be waiving the preliminary examination based on the terms of the offer that have been placed on the record. Is that correct, ma'am?
Yes.
Okay. All right. So may I inquire of Mr. Laredo of his waiver of the preliminary examination?
You may.
All right, Mr. Laredo, you understand you have a right to a preliminary examination today within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You're represented today by Attorney Aaron Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have these negotiations continue in circuit court, Mr. Pappen from the AG's office has placed the term of the discussion on the record. Is it your wish today to waive your right to preliminary examination today?
Your Honor, I just would like some understanding. If I were to waive my right today, I would still be able to negotiate this further at a later date?
Negotiations can always
acknowledging-
continue.
Is this
Negotiations can
acknowledging that I'm-
always continue. Oh, go ahead,
I'm
Mr.
sorry.
Loido.
Is this, if I waive my preliminary right, am I acknowledging a criminal intent or criminal nature to this crime?
No, you're just waiving your prelim today.
Okay, I'll waive my prelim today, sir.
Okay, if your negotiations are to continue the offer that has been placed on the record by the Attorney General. Is that a fair statement, Mr. Pappen?
Yes, it is, Your Honor.
All right. All right, so Mr. Loido, it is your wish today to waive your right to preliminary examination today. Is that correct?
Yes, Your Honor. May I place a brief statement on the record, sir?
No.
You shouldn't say anything on the record because we're recording everything. And so anything you say could be used against you. That's why your attorney is indicating that you should just talk to her. You shouldn't place anything on the record.
Okay.
All right. All right. Do the people, Mr. Pappen, do the people also waive their right to a preliminary examination within 21 days?
Yes, Your Honor.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And then I will provide the documentation paperwork to Ms. Robinson, and then Ms. Robinson, you can talk to your client and see if, here you go. And Mr. Pappen, may I sign the documentation bind over on your behalf?
Yes, Your Honor. Thank you.
All right. I will indicate that will keep Mrs. Ells from signing on your behalf. I will sign via Zoom on behalf of the Attorney General. So the examination was waived on today's date. That's May 16th. Is there anything else to come to the court's attention before I sign the bind over documentation, Ms. Robinson?
No, Your Honor, not at this time.
All right. Mr. Pappen?
No, Your Honor.
All right. I will sign the bind over documentation. Mr. Laredo, your time in district court is done. You're off to circuit court. Well, you'll get your next appearance, when to appear, from your attorney, Ms. Robinson. All right, sir?
Yes, sir.
All right. Anything else for the record in 25-01285, Ms. Robinson?
No, Your Honor, thank you.
Mr. Pappen?
No, Your Honor.
Okay, you should be all set. Thank you for your appearance today. Thank you for your appearance today, Mr. Laredo.
Thank you.
Oh. Did we want to bring up Miss Curry?
Yes, I believe that would be great.
All right, let's bring up Miss Curry. And then
I believe Mr. Cervantes appears
still-
to be.
is he here?
Yes, he's here. He's here.
Well, I think there's some other documentation.
Okay.
So let's go ahead and, after you're done getting Mr. Curry, you will get the other documentation.
You want me to go get them right now?
No, I want you to do it after we get Curry. Yeah.
On that one, Your Honor, I don't have an appearance for anyone yet. Does the court have?
Yeah, we don't have any appearance, and we've got some other warrants that are out that we're just gonna put them all together, so.
Thank you.
You had a big.
Then while we're waiting on Curry, Ms. Donnelly, do you have
Harvey.
on Harvey?
Yes.
Let's go ahead on Harvey. That's set for PCC, right?
That's a PCC we're leaving on.
9/6/20.
And that's on both Harveys. All right.
I'm not, this is.
Yeah, just give me-
Sorry.
All right, so we're on the record in docket 23-3513 and 25-00166. That is People of the State of Michigan versus Dante Harvey. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Dante Harvey, who is standing to my right.
And sir, on both files, you are Dante Harvey, is that correct? Thank you. This is the time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, at this time, it's my understanding that we'll be leaving this up for a preliminary exam. No offer has been extended at this time.
And is that a fair
Oh,
statement?
just kidding. Nope, I did extend an offer at this time.
All right,
There is an offer, Your Honor,
All right.
and the defendant and I will consider it.
all right.
I apologize.
So, but that is correct statement. Besides the whole offer,
Yeah,
we're leaving on for prelim on May 23rd.
yes.
All right, so we will leave this on for prelim for May 23rd at 9 a.m. on both files 23-03513 and 25-00166. That'll be next Friday at 9 a.m. Anything else for the record in 25-00166 or 23-03513, Mrs. L?
Not for the people.
Ms. Donnelly.
Not for defense.
All right, Mr. Harvey, we'll see you next week. Thank you.
There we go. I'll get away from this. Oh. There you go.
I believe we could call the
You're good.
Christopher
You're
Jackson
fine.
case really quick. I believe we're going to be asking for an adjournment.
All right, yes.
The people have not received any information about the violation.
All right. So, Mr. Jackson, you can come up here.
It was sent to your address.
I haven't received anything either, Your Honor.
All right. All right, so
Sorry, go ahead.
and then we'll put it on the record, just so it would appear that the prosecutor may or may not have gotten it, but definitely the defense attorney hasn't gotten it. And so we want to review it before we go forward on the hearing.
It is, and I just want to be clear, because of the process, it doesn't come directly to me. Our admins may have it, and it has been sent. to me,
Right,
so.
and I think that's a similar process. I don't know if we send it directly to,
We send it, there's email groups at the prosecutor's office that it gets sent to, and then the prosecutor's part of Discover sends it to wherever you guys.
I
send
think you're
Discover.
part of the same administrative, it goes to somebody else and then it comes to you.
Yes.
Yes.
I believe so.
So we're all caught up in that bureaucratic nightmare, okay? All right, so we're on the record in docket 25-01070. That is People of the State of Michigan versus Christopher Jackson. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Kaplan.
Your Honor, Jeffrey Kaplan, P 74943, on behalf of the defendant who is standing to my right.
And sir, you are Christopher Jackson, is that correct?
That's correct,
All
Your
right,
Honor.
thank you. All right, this is the time set for it's a PA 53 violation. I have it as a PA 53 or contempt violation. Mrs. L, how are we proceeding?
Your Honor, at this time, it's come to our attention that the violation information has been sent to our office. However, I have not received it personally and have not been able to review it. Additionally, it has not been sent to defense. At this time, we would ask for an adjournment to get that information and get it sent to defense.
All right, and that's a fair statement, Mr. Kaplan. You don't have discovery in this matter concerning the violation.
Correct, and actually, in thinking on it, I did email your admins, and they did tell me I have to get it from the prosecutor, so it probably was not sent to us.
Right. It comes via discovery.
Correct.
All right, so we'll adjourn the PA 53 violation. What's the time frame are we looking at?
If we could get maybe 3 to 4 weeks so that I can go back and see where it is in our office.
All right. Your Honor, I should note that this is scheduled for sentencing June 27th, as it is.
All right.
I can make this happen in 2 weeks if that's preferred.
All right. Good. June. Let's try 2 weeks out. That'll be previous to sentencing. I'd like to have this done before sentencing, but let's see what.
June 6th at 9.
Okay, June 6th at 9 o'clock. to June 6th at 9 a.m. All right, so we've rescheduled this for June 6th at 9 a.m. That would be on the underlying PA 53 violation or contempt violation that'll be in the possession of the prosecutor and hopefully makes its way to your defense attorney for zealous advocacy. All right, sir?
Yes, sir.
All right, anything else for the record in docket 2501070, Mrs. L?
Not for the people.
Mr. Capson?
Not for the defense, Your Honor.
All right, thank you for your appearance. We'll see you on June 6th. Okay, sir?
Thank you. Yes, Your Honor. Thank you.
Talk to you before then.
Yes.
Ms. Curry?
Yes, Your Honor.
Yeah.
Want to approach for the advice rights?
Yep.
No. Thank you, Mr. Johnson. All right, so we're on the record. We're on the record in docket 2500838. That's people of the state of Michigan versus Anna Curie. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Johnson.
Good morning, may it please this honorable court. Kareem Johnson, on behalf of Ms. Curry, stands to my immediate right.
Ma'am, you are Anna Curry, is that correct? All right, thank you. This is time set for I believe this is
PCC, Your Honor.
PCC. Probable, I've got it as a prelim. But regardless, Mrs. L, how are we proceeding?
Your Honor, at this time, offer has been extended to the defendant through defense counsel. It's my understanding that offer will be accepted today. The offer is to plea to a added count 2 of use of methamphetamine under 333.74042A. Actually, I think it's AA at the end. And that is a 1-year misdemeanor and/or $2,000 fine. Upon successful plea and sentencing, we will be dismissing count 1, the possession of methamphetamine.
And Mr. Johnson, is that a fair and accurate statement of the plea offer?
Yes, Your Honor, it is.
All right. May I inquire of your client, Ms. Curry, of their advice of rights and her signature?
Yes, Your Honor.
All right. Ms. Curry, you understand you have the following rights concerning this jury trial. You're going to be pleading to the 1-year misdemeanor of 1 year and or $2,000. It can be punishable by that amount. You have signed your advice of rights, your 12 rights indicating that you understand the rights. So I'll just go through the 3 main ones with you, but that has your signature on the bottom. Is that correct, ma'am? Okay. You understand that you have the right to be tried by a jury, to be presumed innocent. You have the right to counsel. You're represented today by attorney Mr. Johnson, Kareem Johnson, who to be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. And you have the right to silence in this matter. Do you understand that?
Yes, sir.
You have the right, if your plea is accepted, you'll give the claim the plea was a result of any promises other than what we've placed on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial since you won't be having a trial, you'll be pleading guilty instead. Is it still your wish today to plead guilty to the misdemeanor charge?
Yes, Your
All
Honor.
right. I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, thank you. I'm gonna bring your attention back to September 6th, 2024, at the location of Delta River Drive, Waverly Road in the city of Lansing, Hingham County. Were you at the Delta River Drive, city of Lansing address on September 6th, 2024?
Yes, Your Honor.
Okay. And on that date, did you knowingly use cocaine? Methamphetamine? Okay. Did you knowingly use methamphetamine?
Yes, Your Honor.
All right. And you knew it was methamphetamine when you used it? Said yes? All right. All right. And you were not prescribed any methamphetamine, is that correct?
No, Your Honor.
Okay. Anything towards a factual basis, Mrs. L?
No, Your Honor.
Mr. Johnson?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. And we will refer to probation.
Yeah, would the court consider immediate sentencing? My client is under probation violation proceedings in Gladwin County. And then she has 3 other matters in Eaton County that I do represent her on. So she's not,
right.
We're going to ask for a jail sentence and close the matter out. She's not going to go anywhere anytime.
Well, let Mrs. L.
Your Honor, we wouldn't have any objections to that, understanding that the court doesn't really have an updated,
I think that would be the only is, do you have a date of sentencing on the other stuff?
Not Gladwin. The only thing she's scheduled for sentencing is in Gladwin County. That date is
The 21st of May and June 6th.
June 6th. So ours would be past that. With the understanding that you could pick up a bunch of credit on this one if we set it, because if you're incarcerated, then you're incarcerated on all of them. That would be my thought.
I think that would work for us.
And then we do some, and then we have at least a little, but I understand what Mr. Johnson's saying. There's going to be supervision at other counties, and I don't want to duplicate any of that supervision.
Well, legally, once she's under sentence in Gladwin County, she will not get credit in this county or in Eaton County.
All right.
But if the court is indicating that,
the
reality is she's in jail.
If she's in jail, I'm going to give her credit for whatever time she's in. She's got a PR bond here, and she's obviously incarcerated. I would give her any credit for any time on any other case. That makes sense to me because you're not out. All right. So we'll refer to probation. I think your probation, I don't know who your probation agent is. He would have to contact the other counties to see where we stay with this. We may or may not need it depending, but let's refer. So probation will be out to see you. You're currently in Gladwin County. Yeah. So I'm not sure how they do that. They'll probably do that via Zoom. I would assume. And then we'll set a sentencing date. And I think we're setting it out in July, aren't we? So
July 17th at 9.
we'll set for sentencing July 17th at 9 o'clock. Refer to probation with the understanding that you're receiving any credit while being incarcerated. That's A1. 2, we don't want to duplicate any services that are already out or that have already been awarded. Okay. But we do want probation to write a report in this matter. Anything, so except July 17th at 9 o'clock. Anything else for the record in 2500838, Mrs. L?
Not for the people.
Mr. Johnson.
We just asked the court amend the bond to a $50
something
cash bond just to make sure she gets credit.
Yep. All right. So I'll amend or modify the bond. That's a good idea. Or modify bond to 510%. And that'll get setting a bond gets you accumulation for all this time. All right, that you're not getting out anyway, so we might as well have you get time on this file too. All right, so that'll be a $50 bond set on this. Anything else for the record in docket 2500838, Mrs. L?
Not for the people.
Mr. Johnson.
No, Your Honor.
All right, Ms. Curry, we'll see you on that July date. Thank you for your appearance today.
Everybody have a good weekend.
You too, Mr. Johnson. Aaron, you're here on King
Ian Scott.
and Scott, and Mr. Etheridge, you're here on Jax. All right. So do you want to go on Taekwon King?
Sure.
Mr. Silverthorne's been waiting patiently on Arnold. Should we get Mr. Arnold?
Where is Mr. Arnold?
I think he's incarcerated.
And he should be on the TV because it's a PCC.
He is incarcerated,
Mr.
Your Honor.
Was he brought over or is he on Zoom?
He appeared earlier on Zoom. He's the person that broke in. I was afraid he was going to leave the cell. And so I inadvertently also broke in and told him to stay put.
All right, we'll email the county jail just to let them know that we're ready to call that case.
Thank you.
And then I don't know what they'll do there. So, I don't know what they'll do with our email. So, all right, so we're on the record in docket 25-01167. That is people of the state of Michigan versus Taekwon King. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. King.
And sir, you are Taekwon King, is that correct? Thank you. This is the time set for PCC hearing. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be left on for the preliminary examination.
And is that a fair statement, Ms. Robinson? We're going to leave on for
It is, Your Honor. Thank you.
So we'll leave on for preliminary examination on May 23rd at 8:30. So that'll be next Friday at 8:30. Anything else for the record in docket 25-01167, Mrs. L?
Not for the people.
Ms. Robinson.
No, Your Honor. Thank you.
I'll see you next week at 8:30 on Friday, okay? Thank you. And then did you want to go on Scott?
Yes, if we could. I believe it will be a bench.
All right. What's that?
To add to hers, she's got probably 10 or 20.
All right, so we're on the record. Oh, she failed to appear for the precincts also. All right, so we're on the record in docket 24-03149. That's people of the state of Michigan versus Angela Scott. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Ms. Scott.
Yeah, this is the time set for sentencing in the matter. This was set for 9 o'clock.
Yeah. She's not here.
It is now 11:41. It would appear that the defendant has failed to appear for the sentencing. I have an indication that the defendant has previously failed to appear on April 2nd and April 9th for pre-sentence. So there's no pre-sentence done on this file by probation officer Joe Sumter. I have checked the Zoom courtroom and physical courtroom, and we've called the name in the hallway. There's nobody that answering by that name in the hallway. Mrs. L, how would you like to proceed? It appears the defendant has failed to appear for sentencing.
Thank you, Your Honor. At this time, based on the defendant's, I will say pattern to fail to appear, not only in this case, but in other cases that we have had in this courtroom, at this time, we would be asking for a bench warrant to be issued.
Any comment, Ms. Robinson?
No comment.
All right. We have previous failed to appear and previous to probation. We have a previous failed to appear on March 6th on this file. I'll issue a bench warrant and a bond forfeiture on this file. Anything else for the record in 24-03149? Mrs. L.
Not for the people.
Ms. Robinson.
No, Your Honor. Thank
All right,
you.
you're all set. Thank you for your appearance today. And Mr. Etheridge, are you ready to go on Mr. Jacks? Did Mrs. L, are you ready to go on Mr. Jacks?
Yes, Your Honor. Yeah.
I should ask both parties. All right. All right, so we're on the record in docket 24-03253. That is people of the state of Michigan versus Daryl Jacks. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek Esposito, the public defender on behalf of Mr. Jacks, who's in the courtroom standing to my right.
Sir, you are Daryl Jacks, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination. I have it as preliminary examination. Mrs. L, how are we proceeding?
Your Honor, at this time, the necessary witnesses for the people's case have failed to appear. We have sent a subpoena to the address we have on file, but it came back to our office unserved. We have attempted to reach out through phone call as well. However, the number we have on file is disconnected. At this time, we do expect a motion from the defense.
Mr. Etheridge.
Your Honor, this time we're motioning the court to dismiss this matter without prejudice. I've discussed this with Mr. Jacks. He was making the same request. He understands the court could reissue, or the prosecutors rather could reissue this at any time during statute of limitations. Your Honor, he's currently on a PR bond, but he has tether that would have to be removed. I've also advised him not to have any contact with the alleged victim for at least 24 hours so the matter could be removed from lane. Thank you.
All right, so I will have printed out a dismissal or nollie pros based on the prosecutor's representations of their inability to proceed. Complaining victim was subpoenaed and has failed to appear today. So, Mr. Jacks, I'm going to dismiss without prejudice. This could be reissued, okay, and you'll have to go through you'll go through the same arraignment process again. But this could be reissued, but for our purposes today, the case is dismissed. All right, sir. All right, and so I'm dismissing without prejudice. We will make sure that we'll email, so you'll have to go back to the Ingham County Jail. That's where they put the tether on to remove the tether, all right? And we'll email them so they have you coming on that. The GPS tether should be removed. And then I would wait, as Mr. Etheridge indicated, I would wait about 4 or 5 hours to have it completely purged from the system, especially in regards to no contact, all right, sir? All right, anything else for the record in docket? I'm granting the dismissal without prejudice. The people could reissue if they choose to. Anything else for the record in 24-03253, Mrs. L?
Not for the people.
Mr. Etheridge.
We just request 2 copies of the signed dismissal.
Absolutely. All right, so we'll provide 2 copies of the dismissal. You're all set, Mr. Jacks. Thank you for your appearance.
All right, thank you, Your Honor.
Thank you.
Mr. Silverthorne is here, I believe, with his client.
I'm just trying to find Mr. Silverthorne's client.
Oh,
I've emailed.
okay.
Mr. Silverthorne's been here since like 9.
I'm fine. I've been able to keep working.
You seem less hot than we are. It actually seems temperate.
Yes,
there.
I can. That building is notorious.
Yep. All right, so we'll await Mr. Arnold to come in for his. He was previously here and then he was taken out. We've emailed him. And then who's here on the Wasson case? All right. And I think she's out, right?
She's outside, yep.
You can bring her in, yeah. And then Megan's taking down the.
I already know what's gonna happen. I definitely saved my part.
Okay.
All right. All right, so we're on the record in docket 25-00662. That is people of the state of Michigan versus Vanessa Renee Wasson. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Annette.
Good afternoon, Your Honor. George Annette, Assistant Public Defender, representing Vanessa Renee Wasson for purposes of sentencing.
All right, and ma'am, you are Vanessa Renee Wasson, is that correct? Thank you. This is the time set for a sentencing in the matter. Ms. Zell, is there any additional restitution in this matter?
No, Your Honor.
That you know of, okay. Mr. Annette, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, we had a chance to go over it a couple days ago and also this morning.
All right. Any additions, deletions, or corrections?
No, Your Honor.
On that Cervantes stuff, I think we can arraign him on that stuff.
I just grabbed the.
You grabbed everything? Okay.
You want them?
Yeah. All right, allocution, Mr. Annette.
Thank you, Your Honor. When I spoke with Ms. Wasson a couple of days ago, we went over the PSI a little bit with her attorney on record, Mr. Goodrich. We also spoke this morning about it. She was here on time. She was very remorseful for her actions. She knows what she did was not okay. She understands and accepts full responsibility for her actions. She wants to move this issue, this case behind her, move on with her life. She indicates that she's doing good. When she got released from this incident, she went to AA on her own volition, did 4 sessions over there. Ever since then, she's been staying sober, not having any issues, not reported any issues. More importantly, she has not violated the no contact order. She made it clear that she has had no contact with her son, which is going to be asking to see whether you will be able to consider maybe lifting the no contact order for purposes of phone communications, at least to start off. She wants to build a relationship with her son. She understands that, this may or may not be allowed today, but maybe down the line. But she's asking for that today. She also wants to make a very brief statement towards the end, Your Honor. In regards to employment, she is not employed. It says obtain, maintain employment. That's going to be an issue. She has been having issues with work for about 4 years. She can explain a little bit further. Essentially, she's trying to get some assistance that requires her not to work. So that's something we have to at least look into. Other than that, Your Honor, she understands the 10 months probation is being recommended. She's ready, willing, able to continue with that or to start that. And she's ready to lead a better path going forward with this, Your Honor. Thank you.
All right, thank you, Mr. Annette. Ms. Watson, is there anything you'd like to say to the court before the court passes sentence?
I'm extremely remorseful for my actions. I do take full responsibility. I'm hoping that I'll be able to try to reconnect with my son, at least to let him know how sorry I am at some point.
It's an adult son, Your Honor.
All right. So this is Mrs. L. Anything on this file concerning sentencing?
Your Honor, we would just ask that the 10-month recommendation from probation be followed. Additionally, we would like to ask for the anger management and substance use to be ordered as well. Those treatments at least be ordered as well. It sounds like from this incident, anger management could be something that could be worked on, and we would like to see that be part of this probation. Further, we have not had we have had contact with the victim in this case, but have had no indication of a desire for the no contact order to be lifted at this time.
All right, thank you. All right, so this is for a guilty plea that was taken on March 20th, 2025 to the aggravated assault 1 year. I'm going to indicate that the defendant is to spend 4 days in jail. Credit is given for 4 days previously served. I'm going to suspend the remaining 90 days upon successful completion of probation. So there's no upfront jail in this matter.
Okay. Yeah, is it 90 days or is it longer?
It's 90 days. 90 days upon successful completion of probation at this time. The fines and costs, I'm going to set it fines at $250, costs of $250. Crime victims' rights fee of $75, state minimum court cost fee of $50, and then on probation for at $30 a month for 10 months. So I'll give you a total of that. That's 500 plus 125 plus 300.
Yeah, I forgot to ask. Is there any fines that can be waived? I'm not too familiar with the fines and costs. This is my second sentencing.
Yeah, not on the aggravated assault, I don't think. At least I'm not willing to waive it on aggravated assault. So the grand total of $925. The probation, so that'll be over the course of probation, okay, for the 10 months. Probation is allowable via Zoom. I'm going to continue the no contact order with your son, the adult son, Chance DeFore, but he can contact probation and he can indicate that he wants to modify the bond, okay? And then we'll entertain it through probation. It probably just needs some cooling off time, all right? I tell you the truth, probably 30, 60 days to cool off, and then we can go from there, all right? But I'll wait to hear from the victim in the matter. So the no contact order will stay in place until I hear from Mr. DeFore. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, controlled substance, submit to random PBTs and or urinalysis as directed, and no bars or nightclubs. Mr. Ford, this is an unfortunate event, okay? Let's hope it's just a one-off, all right? But if there's any resources district court can use to help you, I'm not concerned with Ms. Wasson now, okay? You're on probation to me, all right? And so the easy fix is to just you're not supposed to be able to get alcohol in jail, right? And this stemmed from some of that, all right? I don't know what else it stemmed from, but it did stem from some of that. But I'm more interested in Ms. Wasson 5 years from now. You're gonna have to make good decisions, good anger management decisions, good decisions based on lucidity. And if there's a problem, we need to know because we need to address the problem, all right? That's the key here. So I'm going to order that complete the following rehabilitative services: outpatient substance abuse at the desire of the probation agent, anger management group at the desire of the probation agent, no purchase or possession of firearms, ammunition, or weapons of any kind. I'm going to strike the obtain and maintain employment until we get a handle on if that's going to be through disability or something else. Okay. I don't want to make that a condition of probation because if you're unable to get employment at this time, that's going to be a problem. And I don't want, as you can tell, we don't want to set you up for fail. That being the case, what people usually come to me for on probation violation is testing dirty. Alcohol or controlled substance, they test dirty. And then we're forced to indicate, okay, there might be a problem here. Let's get resources in. That's what we're for. That's what we're supposed to do, okay? And if we address that problem, that's good. If it's a one-off, not a destructive relationship, then we don't have to worry about it, all right?
I do have my medical marijuana card. I've had it for 10 years.
Make sure your probation agent knows about it, and then he may make a copy for the file. So I will indicate that I will allow medical marijuana with the card to the probation.
I sent an email last month to the probation officer.
Okay.
Just to make sure they have the front and back, but I'll reiterate it.
Yeah, just make sure that that they have the front and back. Okay. Anything towards the judgment of sentence, Mrs. L.
No, Your Honor.
Mr. Annette.
One last thing I forgot to mention, testing. She does not drive. She does not have a license. Getting to testing locations may be a difficulty, as well as some financial problems. Is there anything that you know of? Maybe I forgot what it was called, the daily handheld monitor or anything like that?
The probation agent may know something. I'm going to leave testing because it's a part of finding out what the relationship is with alcohol and controlled substance. And but the probation agent may be able to work around that. I know there's also public transportation that's available. You are one of many to come to the court saying, I can't get there. Make sure your probation agent knows, but you do have a responsibility to test, all right?
Yes, she had mentioned the ankle monitor or a mobile breathalyzer.
All right. If she wants to bring any of that to my attention, I'm willing to look at it, all right? Okay.
Nothing further than Your Honor.
All right, thank you, Mr. Nett. So I'm going to sign the judgment of sentence. Please keep in contact. Who did the report here? So Ms. Bayless did a report here. So please keep in contact with Ms. Bayless, all right? She will let you know.
The probation officer.
Yeah, your probation officer. She should be your probation agent. Keep in contact with, generally the person who writes a report is responsible for as a probation agent, make sure you're on board. She would be the person who violates you. So that's the person you want to keep happy, all right?
Absolutely.
All right, that's all for the record in 2500662. You're all set, ma'am.
Thank you, Ron.
Thank you.
Well, we're not together.
Judge, can you ask if there's anybody in the county rooms? Probably Thomas is sitting in there in the dark.
So Mr. Silverthorne, is Mr. Arnold in any of the rooms? Because they're telling us he might be in a dark room.
Oh.
But I don't, but that's a problem because it's dark.
I can't, I do see a couple dark rooms, post 3
Right.
and post 2, but
Is there anybody in post 2? And post
it's
2 will
dark.
have to unmute.
And I don't see movement. Usually I could see even a silhouette. And I don't see a silhouette in post 3 either.
All right. I don't see a silhouette and I don't see any movement. Mrs. Zell, I don't know if we're gonna get Mr. Arnold back. That's a PCC.
It is, Your Honor, and it was, I believe we were just going to be setting it for the preliminary exam.
Were you gonna leave that on for prelim, Mr. Silverthorne?
That's correct, Your Honor, and I confirmed that again with him today, and I spoke with him 2 days ago at my initial
Okay.
interview and confirmed with him he was adamant about it. I would note that he is here, so, I mean, he was in jail, so he can't be held
Right.
for that. And also keeping on a PE is expansive, whereas waiving a PE without a client would be more restrictive and would have some concern, but
Well,
I don't
I'm
think
gonna
that
indicate
there's
that
any
we're waiving
prejudice
his
with keeping it
appearance.
on.
Right. I'm going to indicate we're waiving his appearance because I did see him here. He was here. And then
Yes.
we got caught up in other matters. So, all right. And then we'll leave it on, and then I'll leave it for you, Mr. Silverthorne, to address any future discussions with Mr. Arnold. Okay.
That's fine. Yes, I'll be seeing him before the preliminary exam.
All right. So we're on the record in docket 22011402 and 25011349. That is the people of the state of Michigan versus Montrese Arnold. Will the parties please introduce themselves for the record, Mrs. Zell?
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Silverthorne.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender, appearing on behalf of Montrese Arnold, who I note is not on screen now, but we would all note that he was on screen earlier today, so he has appeared.
All right, and for the record, Mr. Arnold was on screen. We had a busy docket this morning, and then he was taken off. He did come via Zoom from the county jail. We know where he is. So, but he did appear for the probable cause conference. Ms. Zell, are you satisfied that we can waive his appearance today, Mrs. Zell?
I am, Your Honor.
All right, we'll waive the appearance of the defendant for Zoom purposes. Mrs. Zell, how are we proceeding on the PCC?
Your Honor, it's my understanding that we will be leaving these set for a preliminary examination.
And is that a fair statement, Mr. Silverthorne?
It is accurate, Your Honor, yes.
So we'll leave on for prelim on May 23rd at 9:30 for both files. And Mr. Silverthorne, you'll instruct your client of the same, that it's left on for prelim on May 23rd at 9:30. Is that correct?
I would. He would probably be surprised if I instructed him otherwise, since he was very adamant.
All right. Anything else for the record in 22011402 or 25011349, Mrs. L?
Not for the people.
Mr. Silverthorne.
Not for the defendant, Your Honor.
All right. You should be all set. Thank you for your appearance today and your patience. Thank you, Mr. Silverthorne.
All right. Go someplace cool.
Yeah, we'll try. We'll be in this building.
All right. Bye-bye.
All right. And then Mr. Cervantes, you can come up here. Are these all the TAs? All right, so Mr. Cervantes, we're set for probable cause conference. Then we've got to address these other files. they're all failed to appears, okay?
All of them?
All of them, yeah. So that's why it took us some time to put them all together. Okay, so we're on the record in docket 25-00968. People of the state of Michigan versus Anthony Michael Cervantes. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Mr. Prosecutor, with you.
And you are Anthony Michael Cervantes, is that correct? All right, thank you. This is the time set for probable cause conference. Mr. Cervantes, you are not represented by counsel today, is that correct?
No, sir.
Okay. Have you made application to the public defender's office?
I have.
Okay. Do we have any indication?
I got denied the first time, and then I called them and we talked about it, and like they resent it in.
And you haven't heard back?
I haven't heard back. I did talk to a lawyer though, and I'm supposed to meet with him Monday to like get him.
And what attorney did you seek? That's your retaining attorney.
Yes, Nichols
Mike.
Law.
Nichols.
I could show you on the
What was the last name?
Nichols.
And first name, his first name Mike?
I don't know.
Okay. There's somebody in, so it's perfect. So what I would intend to do, what I think is appropriate here is let's address these other files and let's leave it on for prelim. I think that's fair. That'll give you time for the public defender's office to get back with you, or Monday to seek your own counsel. All right. But let's leave on for prelim because this is a PCC. So we'll leave on for prelim for May 23rd at 9 o'clock. Now, if you show up without a lawyer at prelim, what you're going to get is I'm going to instruct you, you got to get a lawyer because this is a felony file and it starts turning into a big deal. Okay. But let's see if the public defender can get back with you. If not, if you retain counsel or if you get retained counsel, that's where the discovery would go. So they'd have to file an appearance on your behalf. All right. Okay. So we'll leave on for next Friday at 9 o'clock. So anything else on that file, 25-00968, Ms. Azell?
Not for the people.
Any questions of me, Mr. Sanas? All right, and then let's address your other files because I think they're all failures to appear. We have a failure to appear for a 90-day misdemeanor. I don't think you ever arraigned on this.
I know I've got like a lot of them for like suspended driver's license.
Yeah, we've got a no ops that it's been on that is a fail to appear. You got a fail to appear. This one you've been arraigned on.
So when were they?
We're gonna have to cover all that because this is an old one. This one was under Judge Clark. So you have one new arraignment that I see.
I should have only had one failure to appear, and that would have been the
I've only got a bunch of files with your name on it. All right. All right. So this one, the arraignment was set for February 25th. Pretrial was set for April 21st. Pretrial was reset for May 12th at 9:30. You were arraigned on this file. There was an indication to the magistrate that you mixed up your days.
Yeah. Yes, sir.
What's that? All right. And then you failed to appear on May 12th.
Yes, sir. Yeah, I went to I was on the Zoom. I was with East Lansing though. I thought it was for them, but no.
All right. So let's go. You've been arraigned on this file then. Okay. Okay. So we're on the record in 25-00627. That is people of the state of Michigan versus Anthony Cervantes. You have been arraigned on this file. This was for a fail to appear. Bench warrant and bond forfeiture was issued. Do you understand the nature of why the bench warrant was issued for your arrest? So it's a fail to appear. Okay. So we will set this for additional pretrial.
Could we possibly do like
I'm gonna try to set them all at once.
Yeah.
But I don't know where the others are, but let's see. Here's the problem is that you're set for prelim next week and you've got a bunch of failed to appears, and I don't know if that you're gonna show up. And then we got a problem, okay? We've already got a problem because you got a bunch of failed to appears. It's kind of everything, every failed to appear is now coming to haunt you, okay? And that's a problem. You did show up today and you sat through the whole morning without a lawyer. So I know that if you want to, you can come, okay?
It's just I got, like, they all run together because like I said, I got East Lansing, Eaton County, I got Mason. I did have Clinton County. I'm done with them though for right now.
All right.
So,
Can we set these with the prelim that's been scheduled? No?
These are ordinance cases.
Are they all ordinance? All right, so let's do all, so these are all city cases.
Yes, they are all city cases. So I can set them obviously all in the same city day.
Yeah, let's set them all in the same city day. And then if you fail to appear for that, I'm gonna tell you what's gonna happen, all right? We're gonna remand you to jury, because we're gonna remand you on that date, because I don't know where I can find you, all right? You've got a bunch of failed to appears. And if you don't show up for the prelim, we're gonna remand you because we don't know where to find you. The number one aspect for why we set bond is to recognize that you have to appear when we want you to be in court. And if you don't, well, then we got a problem. These are all driving while license suspended or car cases. So so the community with you at risk is really when you're behind a car, okay? Because you're not licensed to be there. That's the allegation. You also have, though, a preliminary examination that we've talked about, and that's set for next week. Just show up for everything, all right? Because if you don't, our next step, and I can tell you, I don't think my thought process is going to be that different from anybody else. They're just going to remand you, all right? All right, so let's get a date for pretrial on all these city cases.
Next city date, believe it or not, is way out
That's not surprising.
there. June 23rd.
All right.
They will all end up at 9:30 once I can.
Okay, so we'll set this in every case for June 23rd at 9:30. We'll set on the driving while license suspended for fail to appear. There's an indication on this file that you do work out of state. Is that fair? Or I presumed it was out of state. It was this is an indication that you may, but this is an old file. This is 2019, that you did some work on an oil rig.
2019? No, that's not me.
It's Anthony M. Cervantes. And you're Michael Anthony Cervantes?
Michael.
Anthony Michael. I have Anthony M. Cervantes.
4/28/2000. That should be the birthday. 2019. That's crazy. Because I've been coming to court here for a minute now.
Yeah, this isn't the same Anthony Cervantes. This person was born in 1970. Yeah.
Okay. Collections file?
That's Hugh Clark's open file on,
Okay, my bad.
and then this one's at 1970.
Is that Anthony M?
Yeah, that's Anthony M. This is why we do this.
I was gonna say, I thought it was only the May 12th one.
Let's see. This is 2000. This is yours. And this is 2000. So these two are. So let's set. You've been arraigned on all these. So let's set. I'm going to quash any bench warrant. These are all my files too. So I'm going to quash any bench warrant. And we'll set on the same day, so June 23rd at 9:30. And that's file 25-00024. And then on file 2403-720, we'll also set it for June 23rd at 9:30. I'm assuming these are all city cases.
Are you setting a bond?
Bond can continue at $100 PR. If you don't show up next week or you don't show up on the 23rd, you're going to be remanded. All right. You did yourself a service by sitting through this morning. Okay. Because you did appear and you showed up without counsel. But I can't guarantee that I'm going to be as forgiving next time. All right. All right. So you're set for next week for preliminary examination. You'll get notice of that from my court officer, and then you'll get notice of the June 23rd date. Is that right?
Yes.
I think that's what I wrote. June 23rd at 9:30 on the other 3 city files. You'll get notice from my court officer. Mr. Spontes, you should be all set. Okay, sir?
So you say this coming Friday?
It'll be Friday, the 23rd. You should be here, hopefully with lawyer. Okay. And then on June 23rd at 9:30, we'll address the other driving license suspended under the city. Okay.
All right. Thanks, sir.
You're welcome.